Good morning, good afternoon, I guess, today. I am calling to order the Public Commission meeting number 234 of the Massachusetts Gaming Commission at our offices in Boston at 2 o'clock on January 31st. Because this is a particularly important meeting, I want to open with a little more formal statement than I usually do to start our meetings. On Friday, January 26th, the Massachusetts Gaming Commission was made aware of allegations of sexual misconduct involving Steve Wynn. These allegations are deeply troubling and have triggered an aggressive and immediate response from the Commission. As you know, the Gaming Commission operates under the strict constraints of an open public meeting law. Accordingly, today's forum provides the first opportunity for the 5 commissioners to discuss this troubling matter and to discuss a path forward. The purpose of today's meeting is twofold. First, to undertake a process to determine the significance of these appalling accusations on the suitability status of Mr. Wynn, of other principals in the Wynn organization, or on the Wynn licensee itself. Second, to assure the people of Massachusetts of our absolute commitment to the first words of the Massachusetts casino gambling law, and I quote, "Ensuring public confidence in the integrity of the gaming licensing process and in the strict oversight of gaming establishments through a rigorous regulatory scheme is the paramount objective of this statute." That's been our guiding principle from the outset of this commission, and that remains our guiding principle today. The Wall Street Journal is a highly reputable news organization with a respected commitment to journalistic integrity. Their news report was the catalyst for our regulatory review. However, the Commission's ultimate assessment of this matter and any resulting decisions of any consequence cannot be based on anonymous allegations in a news article, but must be firmly grounded in facts established by our investigators, combined with the relevant legal guidance from the gaming statute. As we do this work, we will try to balance 2 critical principles. 1, we will not be party to impugning the character of a person or an organization without appropriate process and clear evidence. 2, we will not tolerate behavior by our qualifier companies or individuals that we believe puts confidence in the casino operations of our state at risk. My fellow commissioners and I look forward to hearing more from the Investigations and Enforcement Bureau about the status of their efforts so far and to gain a more comprehensive understanding of their intended approach to this matter. The Commission will also hear from our General Counsel, who will speak more generally to our responsibility and our authority under our statute. Before we begin, I'd like to reiterate that we have a shared sense of urgency about this serious matter, but careful diligence must be a top priority. The stakes are enormous, and many lives are involved, from the lives of the women allegedly abused, to the lives of the men and women in Everett who are now working on this project, to the lives of the senior executives and board members of Wynn Resorts. We will get this right, and we will get it right as quickly as we can. I understand that we're at the beginning of this process, and there will be limitations to what we can discuss publicly today. It would also, obviously, be irresponsible for us to speculate or to engage in hypothetical discussions before we have the facts. With those limitations in place, I believe we're ready to begin. I think we will start with statements from both Director Wells, the head of our Investigations and Enforcement Bureau, and also Catherine Blue, our General Counsel, and then the commissioners will react to those statements after we've had the full background presentations from the 2 of you. Director Wells.
Thank you. Good afternoon, Mr. Chairman and members of the Commission. As the Commission is aware, on Friday, January 26th, the Wall Street Journal published an article detailing profoundly disturbing allegations of sexual misconduct by Steve Wynn. Given the incredibly serious nature of the allegations, the IEB immediately began a regulatory review of the subject matter, and that investigation is ongoing. By statute, the licensee and all qualifiers must demonstrate suitability by clear and convincing evidence. That obligation is ongoing, and the Commission has the power to review any suitability finding at any time. The allegations here clearly warrant an intense review, not only of Mr. Wynn's suitability, but also of other individual qualifiers and the entity qualifier Wynn Resorts. To be clear for the record, the licensee in Massachusetts is Wynn Mass LLC, a subsidiary of Wynn Resorts, a publicly traded company. As part of the suitability determination, other individual qualifiers, including Steve Wynn and the entity qualifier Wynn Resorts, also went through the suitability process and were found suitable as qualifiers. Notably, the qualifiers are not individually licensed the way we license casino employees. Each qualifier's suitability is a component of the overall suitability of the licensee. Therefore, any potential commission finding regarding Steve Wynn's or any other qualifier's suitability will potentially impact the suitability finding of Wynn Mass LLC, our licensee. The Commission has broad authority over the license itself and any appropriate license conditions according to Massachusetts General Laws, Chapter 23K. General Counsel Blue is expected to touch on this further during her presentation. I have spoken with investigators regarding the 2013 suitability investigation to determine whether or not evidence of the concerning conduct was identified back in 2013 or at any time subsequent to that. Particularly, the $7.5 million settlement agreement referenced in the Wall Street Journal article. Both the lead investigator for the consultant law firm of Michael and Carroll, as well as the state police detective assigned to the investigation, confirmed for me that the allegations and the settlement agreement were not identified at the time and notably were not disclosed by any of the Wynn qualifiers prior to the public release of allegations on Friday. I corroborated that information with counsel for Wynn Resorts, who confirmed that there was in fact a settlement and it was not disclosed to investigators upon advice of counsel. She also confirmed that the settlement agreement itself was not part of any court action or litigation and that no lawsuit was filed at any time. There were no court documents filed that could have been identified in the course of the investigation. This was a private agreement and steps were taken to keep it from the public domain. The circumstances around this $7.5 million settlement and the decision not to disclose it to investigators during the suitability investigation remain a critical element of this review. The scope and methodology of the investigation were identified in pages 5 through 10 of the 2013 suitability report, which was posted online at that time and remains posted on the Commission's website. Gaming suitability investigations are historically focused on financial stability, financial integrity, and corporate responsibility on an entity level, as well as professional good character, integrity, honesty, and reputation of individual qualifiers. That component of the individual qualifier review traditionally includes an analysis of that individual's criminal history, whether there exists any ties to criminal associates, organized crime, or corruption, as well as an evaluation of personal financial stability and integrity. That being said, the Commission has the authority to consider any information brought to its attention as it pertains to the honesty, integrity, good character, or reputation of any of the licensee's qualifiers. And we need to be flexible in opening up any sort of inquiry that warrants attention. The IEB investigatory plan going forward mindful that our role is not to conduct a criminal investigation into sexual assault, is to continue on a regulatory review of this matter, which will consist of 4 components. 1, a review of the suitability of individual qualifiers, including Steve Wynn and other qualifiers potentially involved in this matter. 2, a review of any corporate action or lack thereof contemporaneous with the alleged misconduct. The questions, who knew what when, and what, if anything, did he or she do about it. 3, monitoring and reporting back to the Commission on the corporate response to the information that is clearly now in the public domain. We will be looking at how the company, from the board on down, handles these allegations. And 4, a review of how the current situation potentially impacts the financial stability of the company. So that's my statement for the Commission at this point. I believe that General Counsel Blue has more information for the Commission.
Good afternoon, Commissioners.
Good afternoon.
The Legal Department has reviewed Chapter 23K and the Commission's regulations relating to the Commission's and the IEB's authority to conduct a regulatory review of the type described by IEB Director Wells. The statute and the regulations provide the Commission with broad authority to address matters regarding the suitability of qualifiers and licensees. Section 4 of Chapter 23K in subsection 15 provides the Commission with the authority to limit, condition, restrict, revoke, or suspend a license, registration, finding of suitability or approval, or to fine a person licensed, registered, found suitable, or approved for any cause that the Commission determines reasonable. Section 12 of Chapter 23K outlines the areas that the Commission shall consider when evaluating suitability. Those areas include, but are not limited to, the integrity, honesty, and good character and reputation of the suitability applicant, the financial stability, integrity, and background of the suitability applicant, the business practices and the business ability of the applicant to establish and maintain a successful gaming establishment, and whether the applicant at the time of application is a defendant in litigation involving its business practices. Section 35 of Chapter 23K grants to the IEB the authority to issue orders to cease and desist in activities which violate any provision of Chapter 23K or any provision of the Commission's regulations or any law relating to gaming in the Commonwealth. Upon the recommendation of the IEB, the Commission may condition, suspend, or revoke a license issued under Chapter 23K. Section 36 of Chapter 23K grants to the IEB the authority to assess a civil administrative penalty on any licensee who fails to comply with any provision of Chapter 23K or any of the Commission's regulations. The Commission's regulations outline in more detail the obligations of licensees and qualifiers. 205 CMR 112 imposes upon licensees and qualifiers the obligation to provide all information and documents requested by the Commission, the IEB, or Commission staff. This regulation further requires the licensee or qualifier to be truthful with the Commission and to not knowingly provide false or misleading information. A determination by the Commission that a qualifier or licensee knowingly provided false or misleading information shall result in the conditioning, suspension, or revocation of the license or qualification. 205 CMR 115 places a continuing duty on gaming licensees and qualifiers to maintain suitability and requires both licensees and qualifiers to notify the Commission of a whole host of matters that impact the suitability of the licensee or qualifier. Finally, 205 CMR 116 provides that an unsuitable qualifier may not hold an interest in a gaming license, and it requires that a gaming licensee must have a mechanism in place by which the gaming licensee may effectuate divestiture or redemption of securities or a like process in the event of a negative determination of suitability. WinMass LLC is the Region A Category 1 gaming licensee. Qualifiers in the WinMass LLC license application included Steve Wynn and others. A complete list of the original qualifiers in the WinMass LLC application is found in the December 16th, 2013 suitability report posted on the Commission's website. It is very important to note that notwithstanding the broad authority granted to the Commission in regulating gaming licensees and qualifiers, gaming licensees and qualifiers are entitled to due process as codified in the State Administrative Procedure Act contained in Mass General Laws, Chapter 30A, and associated jurisprudence. This means that after the regulatory review is complete and the facts of this matter are determined, the gaming licensee and qualifiers are entitled to notice and a hearing before the Commission before any final action is taken by the Commission. The process and procedures for that process is described in 205 CMR 101 of the Commission's regulation.
Thank you both. Questions for either?
Yeah, thank you. That's helpful. Director Wells. I agree with your assessment of how serious this matter is and the investigative steps you laid out. I assume that that you're going to make this a priority and you'll dedicate the available resources in which it'll be necessary to do this.
Absolutely. We understand the urgency of the matter. I also understand that the Commission may want some kind of time frame. It's impossible for me to report back out to you exactly how long the investigation is going to take. As you know, Commissioner Cameron, investigations, depending on what you find as you look, can go in different directions.
I wanted to reiterate that knowing that you're making it a priority, but with my background in investigations, you just don't know until you start interviews and start gathering information what the next steps will be and where you need to go with there to follow up on information. So I wanted to assure you that I understand that and that you will have the time to do this properly. Certainly, we just heard about our responsibilities, to everyone involved here, legal responsibilities. But first things first, we need to get the investigation done properly. So I understand you can't give us a time. The second thought I had when you were speaking is certainly and you mentioned some of this, the responsibility that the qualifier has to establish and then maintain suitability. That's their responsibility. So I think it'll be really important that we will be watching the board of directors to see how they handle this matter. That's really important. But at the same time, we're conducting our own due diligence and our own investigation to verify whatever we can with these allegations. So I really thought your point about their responsibility and observing how they handle this very serious matter. So I just kind of wanted to make note of that. Thanks.
For anybody who's new to the Mass Gaming Commission, Commissioner Cameron is the retired lieutenant colonel from the New Jersey State Police. Anybody else?
Just to that, to what Commissioner Cameron was alluding, so there's also been reports about two other investigations, one from the board and one just this morning from the Nevada Gaming Control Board, as well as I understand the Macau regulators are looking into this. Anything you can tell us at this point relative to efforts to coordinate or understand better what those other regulators are doing?
I mean, I think any time you're involved in an investigation where multiple parties are involved, the prudent approach is to be efficient regarding investigatory techniques. But I will have to coordinate directly with the other regulators and see what their position is on that as well.
Anything else, Commissioner?
No, well, just to echo some of your remarks, Mr. Chairman, there's a real sense of urgency, obviously, and it's important to get the facts right because the stakes are very, very high. It would be great to eventually get a sense of the scope and the timing of those three other investigations, and I suppose all of that is in a fluid state, so you'll come back and update us as necessary.
Commissioner Stebbins?
Just to pick up, Commissioner Zuniga asked one of the questions I had, but picking up on Commissioner Cameron's point about, our interest in watching how the board handles this. Going back and looking at the suitability hearing, there was a great deal of testimony given to the company's investigation of that time around either the activities of another board member or an incident of potential expansion of their business opportunities, I think, into the Philippines. What they highlighted in that testimony was the due diligence and the high degree of integrity that they associated with that investigation. In fact, they pointed to the appointment of the former director of the FBI to conduct that investigation. Right. So my point being, I think to Commissioner Cameron's point as well, is that it's our hope that the board will conduct that investigation with the same degree of integrity and due diligence that they did in that other matter. And, we're watching how they proceed. The only other point, Mr. Chairman, I don't want, and I echo your opening statement, but obviously, as has been our practice, we folks that wish to weigh in or offer public comments are encouraged to do so, and we have, the means to do that is we have throughout our licensing process, and remind individuals that we are all distributed those email comments, and we all take the opportunity to read them as well.
Commissioner?
Yes, thank you. I have some observations to make with regard to what Director Wells has very ably described as the nature of the review that is going on. As those of you who are either part of the commission or on the staff know, I'm a relatively new member of the Gaming Commission, and I was not present back in December of 2013 when the suitability hearing of relating to Mr. Wynn and Wynn Resorts was conducted before the commission. So I went into the commission's public archives yesterday and reviewed the testimony of Mr. Wynn, and then also reviewed the course of the hearing. And I think it's apt that in Mr. Wynn's opening comments that in addressing himself to the suitability stage of the inquiry, he stated that the most pressing issue in these moments is that of suitability. And he capsuled what the Commission's core concern in that regard as, and I'm quoting again, our sensitivity to compliance and the way we run our business. He then continued on and observed, also aptly in my mind, as I've come to become familiar with the gaming industry. And I'm quoting here, "Gaming is a business that is unique. We in this industry have sort of a presumption that we need to prove, we need to know the difference between right and wrong, and we know how to conduct our business ethically." He went on to say, "I think that presumption is due to the unsavory and colorful history of gaming as it was conducted illegally earlier since the Depression and bootlegging days, and through the early days of Las Vegas. I am fully sensitive to that, he said. Now, these observations of Mr. Nguyen are actually right on point. That they reflect his view is reflected in the very words of our statute that guide everything that we do here on the commission. And the thrust of that statute is that our obligation is to focus on integrity, and integrity of our licensees and people who require to be qualified. That the chairman has already quoted from part of the statute, but let me quote again from section 1 of the statute, in which the general court is finding and declaring as to what the purposes of the statute are. Number 1, and this was quoted by Chairman Crosby, but it bears repetition: ensuring public confidence in the integrity of the gaming licensing process and in the strict oversight of all gaming establishments through a rigorous regulatory scheme is the paramount policy objective of this chapter. But then goes on to provide, number 2, establishing the financial stability and integrity of gaming licensees, as well as the integrity of their sources of financing, is an integral and essential element of regulation and control of gaming under this chapter. And section 3 is, gaming licensees shall be held to the highest standards of licensing and shall have a continuing duty to maintain their integrity and financial stability. That's the essence of our statutory purpose, and it reflects what Director Wells had quoted again from the statute, focusing at this point of the suitability process on the, quote, professional good character, integrity, honesty, and reputation of individual qualifiers. There is, in fact, on the applicant and on a qualifier seeking to be found suitable or to maintain his or her suitability, a burden of proof to establish by clear and convincing evidence that they are in fact suitable. Now, what I, as a commissioner at this point, urge of the IEB, our bureau, is that as it goes about this task, that it be simultaneously scrupulously fair to Wynn Resorts and to Mr. Nguyen himself, but equally scrupulously diligent. I urge you not to rest until you have credible answers to each of the subject matter areas that you described that you would be focusing on. In all of my prior experience before coming to the commission, as a state prosecutor, later as a federal prosecutor, then as a private lawyer, dealing regularly with cases and circumstances, while not identical to this, nevertheless complex cases where wrongdoing was seriously suspected, is that the single most important thing at this stage is to get control of the facts by finding out what they are as soon as possible. Speed, thoroughness, and objectivity are essential, and I trust that that is the way that the Commission's investigation will proceed. That we have the advantage here of the Wall Street Journal article. It provides, in my judgment, in my professional judgment, a reasonable roadmap of proceeding, at least at the beginning of this investigation. As has been noted, that it confirmed the settlement of a $7.5 million dispute settled privately relating to allegations of sexual misconduct. But that its significance and utility at this point in time goes beyond that. The journal referenced that it had contacted over 150 people in the course of its investigation, and it reported to the world thereafter, and here I quote, "Dozens of people interviewed described a, quote, decade-long pattern of sexual misconduct." Now, beyond just that generalization and conclusion, and beyond the confirmation of the settlement of the $7.5 million claim, that the article also identified named sources. So this wasn't just a situation in which a newspaper or other media is reporting unconfirmed or unstated, unidentified sources. For example, that they identified an individual by the name of Jorgen Nelson, who was described as the former artistic director at the Wynn salon. It identified a Dennis Gomez, who was a former Golden Nugget executive at Las Vegas, who was involved in a lawsuit with the Wynn organization in the early 1990s. He is deceased, but the journal followed up and interviewed his wife, whom they identified, and that she confirmed the substance of what her deceased husband had alleged contemporaneously. A woman by the name of Sean Cardinal, who was Elaine Wynn's former personal assistant, was also named. And finally, a Doreen Wennon, a former senior Wynn executive who allegedly criticized the manicurist who is behind this, or is involved in the $7.5 million settlement, criticized the manicurist's supervisor for having filed a report to the Human Resources Department at Wynn. Now, the journal noted that Ms. Wennon had declined to be interviewed for the article, but yesterday I did my own Google search and found a more recent article about Ms. Wennon, in which it was reported that in connection with the pending litigation between Mr. Wynn's former spouse and Mr. Wynn, that she had notes that she had contemporaneously prepared, memorializing the report from the supervisor, existed, and furthermore, that her notes of that report have recently been ordered disclosed by the Nevada court that is presiding over the Wynn litigation. And interestingly, that litigation, according to several articles that I read, is scheduled for trial in April of this year. And so, Ms. Wells and and all of us who are part of the commission. I'll repeat what I said before. I urge that we collectively, the Bureau specifically, be scrupulously fair, but equally scrupulously diligent. Speed, thoroughness, and objectivity are key. And I look forward, as one of the commissioners, to the results of that investigation and your further report.
Thank you, Your Honor. I have a couple of questions. This has been alluded to many times, but just to clarify, the fact that jumps out of this story is the $7.5 million settlement.
Right.
Reiterate to me your understanding of why that was not apparent to us during the investigation.
Correct. So what we have discovered is that that was in fact a private agreement. There were steps taken to keep it private. There were no court records at the time for investigators to discover, and that it was not disclosed by any qualifier. Now, whether or not that was appropriate will be looked at as part of this investigation. So that sort of summarizes the landscape at the time.
Yeah, I get that. I also had a question for General Counsel Blue. I forget what the citation is, but one of the criteria for suitability or for the lack thereof is a pattern of acts which maybe did not get prosecuted, but pattern of behavior which indicates. Would you explain what that is again? How that section works?
So section 12 that we talked about in the overview talks about the things that the IEB and the commission would look at to determine suitability. Section 16 talks about the things that can keep someone from being suitable. One of the parts of section 16, one of the possible ways someone would be deemed unsuitable would be if they had a pattern and practice of misconduct that did not result in a conviction, but nevertheless was there and was able to discern. And it was of some activity that caused concern to the IEB and the commission. So there are a number of matters in section 16, but the one that you're referring to is the pattern or practice of misconduct.
Okay, so there doesn't have to be a conviction. There can merely be behavior that the IEB and then eventually the commission believes is unsuitable. Any other questions or issues?
Sure, just one quick one. I want to go back to something the legal department raised and Director Wells seeing again. We're not sure where the timeline might be, but obviously, there's certainly an encouragement for expediency and thoroughness. But one thing that occurred to me is our request for any particular documents, information that we solicit from the licensee. Would it be your expectation that you would inform the board if you got pushback or denial of those types of requests?
That is correct. So cooperation is a component and it's required. So any lack of cooperation would be reported back to the commission.
This is a really important point, and you've now made this point a couple of times, but it's important to note that issue one, no doubt, will be this payment, this settlement, and all the associated events and allegations around it. But it concurrently is how the company responds to that. That is a measure of the suitability of the company and the principles in the company. So that's an important point to remember. And on the same line, we have adopted a mantra that many of you will have heard, that we are committed to having our processes at this commission be participatory, transparent, and fair. Commissioner McDonald and I both spoke to the issues of fairness here, and they are utterly critical. Transparency is equally huge in this situation, and to the maximum extent possible, we don't want to be in a position where we're operating with knowledge that the public can't have. No doubt there will be pressure, and some of it will be legitimate pressure from the various qualifiers and institutions that you're talking to. But I hope you, and I know you will, but please take it from us as well, that we're going to look on disfavor to keeping things off the record. The public has a right to know. The people in Massachusetts have a right to know what the hell happened here, and no punches pulled, good, bad, or indifferent. And for us to try to be in a position where we're having to hold back something will be something that this commissioner will look unfavorably on. I mean, there are laws, there are rights under the law to certain kinds of confidentiality. We respect that. But a tremendous presumption of transparency to the maximum extent possible.
Mindful of the underlying allegations do involve sexual harassment and sexual assault, so we have to be mindful of protections regarding that kind of activity.
Right, and I fully get that, and I'm saying we will and should comply with whatever the legitimate constraints are. But A, those are gray, they become gray, and B, we just have to have an operating presumption, which is to the maximum extent possible. We want the people of Massachusetts to know everything we know about what's going on here. Anything else?
Can I just mention something that I think you highlighted at your beginning, at your initial remarks, and it may go without saying, but it is tempting to think of multiple scenarios in all of these, and I think we should really resist any of that. The theme here emerging obviously is one of fact-finding first, and we can schedule a meeting just like this on very short notice and come back and as many times as we need to and hear updates if that's the relevant course at that time.
Right.
Yeah, and I just think it's important to give the Bureau time to complete their
Precisely.
investigation. That's critical. Typically, you won't have an update because that may affect a critical piece of the investigation, which is ongoing. So I'm just want to be a little bit mindful of investigative methods and give the Bureau time to complete their investigation.
Absolutely.
All right, is there any other business on the table? Director Bedrosian, anything else?
No, other than I take my job now is to provide the IEB, legal division, and our staff with the resources they need to get this done.
And I would point out that we do have a casino to open in Springfield in about 7 months. So we'll we have a few things to be doing here. Anything else? Do I have a motion to adjourn?
So moved.
Second?
Second.
Further discussion? All in favor?
Aye.
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 The ayes have it unanimously.